All right, so I think we're recording now, right?
Okay. Enjoy
Thank,
your class.
thank you. Good morning, everyone. So we're gonna be left alone today, so it's just me. Let me share my screen so we can go over the PowerPoint. All right, let me see here. Okay. I'm assuming everyone can see my, oh no, wait, let's go back. Sorry, I didn't mean to hit that. Okay. All right, good morning. I'm assuming everyone can hear me and you can see my PowerPoint. If you cannot hear me, just let me know in the chat. But I'm gonna proceed with the assumption that everyone can hear me. So good morning, my name is Georgina Lepe. Today's presentation is titled Realtor's Guide to Probate. Today I'm gonna be addressing various probate techniques that exist, especially when you as a realtor go on a listing appointment. And hopefully this presentation will help you just have a better understanding of the probate world and help you pick up additional listings. Okay. A little bit about my office. If you haven't attended my presentations, my practice focuses on estate planning. Probate's what we're going to discuss today. And lastly, real estate litigation. Obviously, with estate planning, I create trusts, pour over wills, financial power of attorneys, and advanced healthcare directives for my clients. And with probates, you're going to learn about that today. And with real estate law, well, as all of you know, with the eviction moratorium, I'm really not doing many evictions these days, but maybe once the moratorium ends, then we'll commence with that. I handle partition lawsuits, disputes over the earnest money deposit, and breach of contract. So today's agenda is listed here. We are going to cover a lot. It is a lot to take in, but I guarantee you that it will be very beneficial for you for when you go on your listing appointment. If you have any questions during the presentation, write them down on a piece of paper and at the very end, submit them in the chat section. The reason I ask you to wait on submitting your question is that it's very likely that I am going to address your question during the presentation. So it just makes it easier to get all the questions that I haven't answered at the very end. So I'll answer all your questions at the end, but it is a very lengthy presentation. So first, we're going to cover what is probate. Secondly, we're going to go over all these mechanisms that exist to potentially avoid the full-blown probate. Although this presentation is titled Realtor's Guide to Probate, the goal is to avoid the full-blown probate and get the house sold faster and save your clients money on probate. So we're going to discuss joint tenancy, the spousal property petition, which is a summary probate procedure. We're in the probate world, but you don't have a probate sale. So the client doesn't have to pay the high attorney's fees that normally have to be paid in a normal probate proceeding. Property valued under 166,000. And no, I'm not crazy. Yes, I'm familiar with the housing market in California, but you'll know why this is an important mechanism to be familiar with. Living trust, and then we're going to discuss the full-blown probate. When we go over the full-blown probate, we're going to go over forms that you as realtors need to be familiar with, whether you're the listing agent and you're accepting offers, or you're representing the buyer and you're submitting an offer on behalf of your client. There's a new form that came out, I think it was late last year, that you would incorporate it if it was a sale, a probate sale concerning vacant land, a commercial property, or residential income. And then lastly, we're going to go over questions. So what is probate? Probate is the court supervised process of gathering a deceased person's assets and distributing them to creditors and their heirs, and obviously the payment to the attorney handling the probate proceeding. You're in the probate world when you're dealing with a deceased individual on title. So if you go to a listing appointment and the person that you have in front of you tells you, one of the owners or the only owner to this property has passed away, you have to put on your probate thinking hat. We are in the probate world now because someone has passed away and they are on title to a property. Probate is necessary if a person passes away with or without a will. You're going to encounter situations where your clients will tell you, realtor, my mom passed away. I want to sell this house, but don't worry, she left me a will. Here's the will, and I'm the executor. And they think that they have the authority to sign your listing agreement on the spot. They have the authority to sell, and that's not the case. Even if someone passes away with a will, we have to present that will to the judge. The judge has to admit that will into probate and grant the authority to the person listed in that will to act on behalf of the estate. What I mentioned earlier, you may end up in probate courts, but you may not necessarily have a probate transaction. What I mean by that is when you go through the full-blown probate and you're going to sell the property, you need to make sure that the purchase agreement, you use a probate purchase agreement. However, if we do a summary probate procedure where we're in and out of court, you do not have to use the probate purchase agreement. The probate rules concerning the sale do not apply. So it's very important for you to know when it's a probate transaction and when it is not a probate transaction. Briefly, I'm going to go over the attorney's fees that are paid to an attorney handling the probate. We get paid a percentage based on the value of the estate. We're not looking to see how much there is in equity. We go based off the market value of all the assets. So if there's a home, if we're going to probate for just one home, and that one home is worth $500,000, which is a very easy threshold to meet, the attorney will receive at least $13,000. The reason I say at least is because we have the right to ask the court to increase our fees if we're selling a real property and we're communicating with the realtor, we're communicating with escrow, we're having meetings with our clients. So we're able to bill for our time spent on selling the home. Also, the personal representative that assists the attorney with the probate, this would be your client, the personal representative, they're entitled to charge the same amount as the attorney. So if we use the valuation of $500,000 just in attorney and representative fees, the estate is going to pay about $26,000. If the attorney asks to increase his or her fees, this can easily be $30,000. This does not include court filing fees, the probate referee costs, any creditor claims that were filed, or Medi-Cal claims, because when we initiate the full-blown probate, Medi-Cal has the right to send a bill to the estate and say, this is how much we're owed because we provided services to the decedent during his or her lifetime. So when you go on the listing and they tell you there's a deceased person on title, the very first thing you need to look at is there a joint tenancy? Let's look at the last recorded deed. Is there a surviving owner on title? Was title as joint tenants? So as long as you have one living owner on title and title was taken as joint tenants with the right of survivorship, you are not in the probate world. What we would have to do is you would have to remove the deceased individual from title. And you do that by completing an affidavit of death of joint tenancy. But the living person needs to have capacity to sell. So let's assume you go on a listing appointment and you meet with the adult child of the decedent and the surviving spouse. And the adult child tells you, realtor, my mom is on title with my dad, but my dad passed away and my mom lacks capacity. That's going to be a very hard sale. Mom either needs to have a power of attorney already in place, granting someone the authority to act on her behalf, or the family will need to initiate a conservatorship, allowing someone else to act on behalf of the mom. However, if mom has capacity, that's not a problem. You know, you just remove the deceased individual from title and you can proceed with the sale. Like I mentioned, you complete the affidavit of death of joint tenancy. You attach a certified copy of the death certificate. A preliminary change of ownership needs to be completed, and a change in ownership statement of death of real property. Time frame for removal immediately upon recording. As you know, many escrow companies will prepare the affidavit for the clients. Who can complete the affidavit? Anyone with knowledge, not necessarily the other person that is on title. So an adult child who has knowledge of the facts that dad passed away can complete the affidavit of death of joint tenancy. Fees, obviously there's recording fees. The downfall is you do have to wait to obtain death certificates because you need to attach a certified copy of the death certificate. Here is a cutout of the affidavit of death of joint tenancy. You're basically certifying under penalty of perjury that the decedent listed on the death certificate is the same person that took title as joint tenants with the other person that is still alive. The next mechanism that we have available is a spousal property petition. This is a summary probate procedure that I use very often. We are in and out of probate court, and this is not a probate transaction because at the end of the day, the surviving spouse is the sole owner of the property. And this is the fact pattern. Wife or husband approaches you to list and sell the property that she or he and his or her wife owned. But the problem is, title is just in the deceased individual's name. So it's very common that when individuals refinance, one of the spouses comes off title because they get a better rate if it's just husband or just wife on title. Well, what ends up happening is they forget to add their spouse on title, and then one passes away. So if you have a situation where the spouse owned 100% of the property and that spouse has passed away, it's possible that your client qualifies for this procedure. Or if the decedent owned the property as tenants in common, because remember, if it's not as joint tenants with the right of survivorship or husband and wife as community property, if it's as tenants in common, it has to go through probate. So you can use this procedure if husband or wife solely own the property and they have now passed away, or they own the property with their spouse or someone else as tenants in common. What are the requirements? First and foremost, the deceased is survived by the spouse. And the reason it's in red, bold, and underlined is because this is the most important requirement. California does not recognize common law marriages. You will encounter your clients that will tell you, well, realtor, I lived with my spouse for 25 years. Doesn't that make me his wife or the husband? No, it does not. You legally have to be married in the state of California to qualify as a spouse. There's no common law marriage. So you have to ask that question. Were you and the decedent married? As soon as you sense any sort of hesitation, that means they weren't married. They're going to say, well, I called him my husband, or he called me his wife, and we're together for 20 years. We had all these kids together. That's not the spouse. They need to say, yes, we had a marriage license obtained and we were actually married. Secondly, the property is community property. What is community property? Anything that was acquired during marriage is presumed to be a community asset. So you're going to ask your client, when did you get married? When did you purchase this property? So long as it was purchased within the date of marriage, it's possible that we can use this procedure. If the client tells you, we bought this home 1 month before getting married, this procedure is not going to work. The property needs to have been bought during marriage. There's no will disposing part of the property to another person besides the surviving spouse. Most of the time, there's not going to be a will. But if there is a will and it says everything goes to my spouse, then that's good. But if there's a will and it says, well, 25% goes to my spouse, another 25% goes to my mom, another 25% goes to my dog, then that's not going to work. Everything needs to go to the spouse. There's no agreement between the parties that affects the disposition of the property, meaning there's no premarital agreement and there's no postmarital agreement. So basically what this procedure does is the surviving spouse is telling the judge in the probate court, Your Honor, I was legally married to my husband. During our marriage, we bought a home together. The reason I am not on title is because I have very bad credit. I have a ton of student debt, and the lender would only give us a very good rate if it was just my husband on title. However, my husband and I both knew that the house belonged to both of us because we're married and that was our intent. But unfortunately, he passed away and there wasn't enough time for him to add me on title. 50% of the house belongs to me because it's a community asset. 50% goes to me because I am the surviving spouse and we live in a community property state. 50 plus 50 equals 100. So what is the process? First, we file a petition in court. The hearing can be set anywhere from 6 to 5 months out, depending in what county we file. We have to file where the decedent died or had the property. We mail out the notices to the adult children or the minor children that survive. We attend the hearing. If there's no objections, then the order is granted. And then we file a certified order with the recorder's office indicating that the surviving spouse is now the owner of that property and now you can sell it. This is not a probate sale. Why is it not a probate sale? Because your client, the surviving spouse, is the sole owner of the property. She's not the executor. She's not the personal representative. She's the owner of the property. So you can sell it and not have to worry about all the other rules that apply to probate sales. I went ahead and listed the timeframes for each county. LA County, you're probably going to get a hearing anywhere from 4 to 6 months out. San Bernardino and Riverside County, I would say 6 weeks out, and then Orange County, anywhere from 6 to 12 weeks out. The difference is that with San Bernardino County, I can actually walk out of the courthouse with a certified copy of the order the day of the hearing and record it that day. Unfortunately, right now, Riverside County is not allowing us to make any in-person appearances, but I'm assuming once they resume to in-person appearances, this will go back to how it was before, where I could walk out with a certified copy of the order, and then my client would become the owner of that property that day. The statutory attorney's fees do not apply. So this is something very good. Either the attorney is going to charge a flat fee or an hourly rate. My office charges a flat rate for this. It's not the normal statutory attorney fee. So this saves the client money. How about real property valued at or under 166,000? And no, I am not crazy. Yes, I am familiar with the housing market in California, but let's talk about this. This is dealing with property owned entirely by the decedent or a certain percentage of the property. It does not exceed 166,000 at the time of death. You will use this procedure when, let's say there's 6 people on title to the property, all of them hold title as tenants in common, one of them passes away, And at the time of his passing, his 1/6 interest did not exceed 166,000. This is how you will manage that decedent's interest. The court is not going to make you go through the full-blown probate if the decedent's interest in the property did not exceed 166,000. You will also encounter this procedure when people have passed away many moons ago and the children are barely going to initiate probate. You know, you don't have to initiate probate right away. I've had probate cases where the decedent passed away before I was born. You know, that's how long people wait to initiate probate in some instances, especially if there's an adult child residing in the property. Obviously, they don't want to leave and go and pay rent elsewhere. So when you're going on these listing appointments, ask, when did this decedent pass away? If the decedent passed away 40, 50 years ago and probate was never initiated, it's very likely that the decedent's interest in that property did not exceed 166,000. The most recent one I did was for a client. He was incarcerated for a very long time. So when he got released, his mom had already passed away. The house, when the mom passed away, was worth under 166,000. So we were able to do this summary probate procedure for that client because he wanted to sell. He didn't have the means to maintain the house. It was a big house. It was just him. So he's like, why do I want a big house for myself? So just keep this in the back of your mind. What's the process? We have the probate referee appraise the property. That takes about 4 to 6 weeks out. And then we have to make sure that at least 40 days have passed from the date of death. We file a petition in court. The hearing gets set anywhere from 6 to 4 months out. We send out notices, we attend the hearing, and we obtain a signed certified order of the ruling. We record that order, and the heir at law is a new listed owner. This procedure can be used by siblings, by children, because we're looking at the heirs at law. Obviously, if there's a surviving spouse and the property was bought during marriage, you're going to use the spousal property petition. But what if someone passes away and they don't have a spouse and they only have children, well, they have 1 or 2 children, then the children can use this procedure. But if there's no children, then the decedent's siblings, the brothers and sisters, would be able to use this procedure to transfer title into their name. So you're going to encounter the situation where maybe you have 5 siblings that own a property, one passes away, then we would use this procedure to transfer ownership of that interest. Next, we have living trust. Obviously, I have a whole separate presentation on the benefits of a living trust, but what you need to know as realtors is when you go on a listing appointment and your clients tell you, well, we have a living trust, we're going to avoid probate, you need to confirm that title reflects the name of the trust. The last recorded deed needs to have the name of the trust. So you need to call your title company and verify that that's in fact what has happened, because if the last recorded deed is in the name of the decedent, even though they have a trust, you're going to have to go through probate because title is not in the name of the trust. We would probably have to do a EGGSTAD petition or do the full-blown probate. What is the EGGSTAD petition? With the EGGSTAD petition, we're trying to have the court transfer ownership of the property into the name of the trust. So again, in this case, we're in and out of probate court because we're asking the judge to transfer ownership of the property into the name of the trust. So what should you as the realtor be looking at to see if you're going to have a viable EGGSTAD petition? You should look at the schedule of the assets. Is the property listed on the schedule of the assets? If it is, then that's a slam dunk case. We tell the judge, Your Honor, the property is listed on the schedule of assets. For some reason, the decedent never transferred ownership into the name of the trust. We're asking that you, the court, transfer ownership into the name of the trust. or you're looking for a general assignment. Does the trust contain language that states that it is the intent of the grantor for all his or her real property to be owned by the trust? If that's the case, then you have a pretty good argument to make. Specific distribution, does the trust list the property in a distribution provision? Meaning if you're trying to sell the property that's located on Green Street and the trust specifically states my property located on Green Street goes to my daughter, then that's a good argument to make to the judge. But what else should you be looking for? What if you find the original signed deed transferring ownership into the name of the trust, but it was never recorded? Then you can go ahead and record that deed. You would not imagine how many clients I've had them avoid the EGGSTAD petition because they tell me, Georgina, I'm 100% sure my parents signed the deed transferring ownership into the name of the trust. I'm like, well, if you're so certain, look for it. Maybe you can find the original. If you find the original, obviously you can go record it and then you can just sell the property in the name of the trust. But if you can't find the original and you find a unrecorded copy of the deed, then that's a very good argument to make to the judge that it was the intent of the grantor to transfer ownership into the name of the trust. So what is the procedure? We file the EGGSTAD petition. The hearing is set for 2 or 4 months out. We serve all the heirs at law and the beneficiaries. We attend the hearing. If the petition is granted, the judge will sign order transferring ownership into the trust, and then we record the certified order. Again, these are done on a flat fee basis. The statutory attorney's fees do not apply. If you are handling the sale for the trustee, I would have the trustee obtain an appraisal report before listing it, especially if the trustee has difficult siblings that it's likely that they're going to contest the sale. That way you have an appraisal beforehand and you can tell the beneficiaries, listen, it wasn't undersold. Here's the appraisal report and here's the sales price. Always make sure to have the trustee consult with an attorney. Even if they don't want to hire an attorney, it's advisable that they at least consult with an attorney, because there are statutory notices that need to be sent out to all the beneficiaries, and there are assessor forms that need to be completed. So now we're going to go over the full-blown probate, but just a brief recap. So remember, first, we did the affidavit of death of joint tenancy. You're going to look at the last recorded deed. Is there a surviving joint tenant on title? If so, you would just remove that joint tenant. Then you're going to look to see, was the decedent survived by a surviving spouse? And if so, was the property acquired during marriage? If that's the case, it's very likely that you can get a spousal property petition approved and avoid the full-blown probate. Then the next question would be, well, if the surviving spouse is not alive, can one of the heirs at law make the allegation that the decedent's interest at the time of death was under 166,000? If so, then you would use that procedure. And then lastly, obviously, a living trust. If title's not necessarily in the name of the trust, then we would do a EGGSTAD petition. So now for the fun and interesting stuff, what everyone came here today for, the full-blown probate. So like I mentioned, if none of the above procedures work, then you will have to go through the probate process. So what is the probate process? The very first step is that someone needs to get appointed as a personal representative in order to marshal the assets, sell the assets, pay off creditors, or transfer the property or proceeds to the heirs at law or beneficiaries. So step one, someone needs to file the probate petition to be appointed as a personal representative. The personal representative refers to the executor or the administrator. If you don't want to get confused, always use the word personal representative because you won't ever be wrong. But I have cases where the parties will refer to the personal representative as the executor when he or she is not the executor, or the administrator when he or she is not the administrator. So if there is a will, the personal representative is given the title of executor. If there's no will, the personal representative is given the title of administrator. So just to be on the safe side, always refer to your clients as the personal representative because you will never be wrong. So the first step is we file the petition in probate court. As I mentioned before, just because someone passed away and they left the will nominating someone as the executor, that does not mean they have the authority to sign your listing agreement. They don't have the authority to accept an offer and so forth. So we file the probate petition. In that probate petition, if someone left the will, in the petition, certain allegations are made. First, someone passed away. They left the will. In that will, they nominated so-and-so as their executor. We're asking for that person to be appointed as the executor. If someone passed away without a will, then the probate petition reflects, this person died without a will. We're asking so-and-so to be nominated, to be appointed as administrator. Oh no. Okay. So there is a list, priority of appointment. Obviously, if someone left the will, the person listed as the executor will get appointed as a personal representative, assuming they want to assume the position. If there's no will, first it's a surviving spouse that has priority, then the children, then grandchildren, and then other issue. The reason I bring this up is that in cases of blended families, you may have the surviving spouse and the children from the previous marriage fighting to get appointed as a personal representative. And just so you know, if there is a surviving spouse, they have priority to get appointed as a personal representative. Step 2. We have to send out notices. So the first step is we file the probate petition. Normally the hearing gets set about 6 weeks out. During those 6 weeks, we send out notices to everyone listed on the will and to all the heirs at law. We also have to publish it in the newspaper. And then once it gets closer to the hearing date, we check what's called the probate notes. The probate notes are what the courts issue to us, the attorneys, to provide additional information if they're requesting more information prior to the hearing. Step number 3, we attend the hearing. If no one shows up to object, and everything was done properly, then the petitioner, the person that filed the probate petition, will get appointed as a personal representative. And they're given the title of executor or administrator. At that hearing, it's also going to be determined if they have full or limited authority. And I'm going to tell you the differences later on in this presentation, and hopefully you haven't fallen asleep by then, because you as realtors should be familiar what the differences are, whether you're the listing agent or the buyer's agent. And then lastly, whether bond is required or not. What is bond? Bond is an insurance in place to protect the interests of all the creditors and the heirs at law, because remember, the personal representative has full authority. They can take off with all the assets and leave to Europe, and then, they'll spend all that money out there. Wait, I think I need to mute someone. Am I able to do that?
You need to mute everybody.
Hold on, I don't think, okay, there we go. I apologize. I was left alone to monitor everyone and give this presentation. Okay, so I think everyone's muted now. Okay, let me close that up. Okay, so then we attend that hearing. So I think the question that may arise right now is, you're thinking, well, when do I get my listing agreement signed? Technically, to have a valid listing agreement, it's until the letters have been issued. So after the hearing, there's two court documents that get signed by the court. Obviously, one is the probate order. The probate order only reflects what the judge decided at the hearing, who gets appointed, what title they were given, whether bond needs to be posted, and so on. This is not the document that gives your client the authority to act. This just reflects what happened at the court hearing. With LA County and Orange County, we have to submit the order to be filed electronically. So this means we're not going to get a signed order the day of the hearing. In San Bernardino, I can literally walk out with a signed order that day. And like I mentioned before, once Riverside resumes in-person hearings, I am assuming that we're going to be able to do it like we did prior to COVID, where I attend the hearing and I walk out with a signed order that day. This is a cutout of the order. If you're interested and you want to look up the actual form, it's DE-140. And like I mentioned, this is just a cutout where it lists the petitioner's name. They're given the title of executor or administrator and whether they have full or limited authority and whether bond will be required. Then we have the letters of administration. This is a document that actually gives your client the authority to act on behalf of the state. So legally speaking, your client does not have the authority to sign your listing agreement until the letters have been issued. Here's the problem. If bond is required, the letters will not be issued until the bond is posted. And depending on the client's financial situation, some companies may require the payment of 2 years of the premium in advance prior to posting the bond. Others will issue the bond and at the same time will send the bill to the attorney and the client. It just depends on the client's situation. But remember, the letters are not issued until the bond is posted if it's required. And if bond isn't required, then they can be issued once the order is signed. But right now, due to the pandemic, it's a bit difficult to get our hands on the letters or them being issued. Most courts are requiring you to make an appointment. However, with San Bernardino County, if bond is not required, I can get the letters issued the day of the hearing. With LA County, obviously, first I have to submit the order electronically to be signed. Then once it's signed, either I can put in the request by mail or have my client make an appointment and go in person. Here is a cutout for the letters of probate. On the upper left-hand side, you have your client's name, and then I'll say whether they have full or limited authority. So this is the document that you're going to ask for your client to make sure that they have the authority to act on behalf of the estate. So selling the property. So everyone that is asleep, wake up now. This is the important stuff now. What forms are you going to use to sell the property? You're going to use the residential listing agreement. There is no probate listing agreement at the moment. So CAR form RLA. What is the only difference? The only difference is that your initial list term can only be for 90 days. Anything that exceeds 90 days is invalid. So at the end of 90 days, if you are not successful in selling the property, your client can walk away and find another listing agent, or they can renew it for another 90 days. But at the end of the day, it cannot exceed 270 days without court approval. So remember, you're going to use CAR form RLA and just make sure that the term is 90 days. You're going to use the probate listing addendum and advisory CAR form PA, and also the representative capacity signature disclosure CAR form RCSDS, because your client is signing on behalf of an entity, of an estate. I always tell people, think about it like a corporation. When a corporation is selling, ABC Corporation, they themselves aren't signing. It's the president or the vice president that's signing on behalf of that corporation. Same thing with an estate. The seller is the estate, but who's signing off? Then it's the personal representative. Some counties do have restrictions on commission if it's limited authority. For example, LA is 5%. Here is a cutout of the listing agreement. Like I mentioned, the seller is the state of, and then you put the name of the decedent or however the case name is reflected. The 90 days, I put it down here so you can see it, but obviously it would go right here. This term, beginning through the end date, would only have to be 90 days, which is the listing period. And then you would mark this box indicating that it's being sold as part of probate. The representative capacity signature disclosure form, again, you're going to mark box D that the seller is an estate. You're going to put the case number. Where the client signs here, it's actually going to be their signature. So I get asked, well, does a personal representative sign the estate of Billy Jones? No, if the personal representative is Georgina Lepe is going to sign how she normally signs. And then we would print the personal representative's name down here and then their title, whether they're the executor or the administrator. All right, so just a brief recap, listing agreement 90 days. I would not get it signed until the letters have been issued. If you get the listing agreement signed prior to the letters being issued and your client wants to get out, all I would argue is you have an invalid listing agreement because the client did not have the authority to act on behalf of the estate. If you then tell me, well, Georgina, I put in my listing agreement subject to the client being appointed as a personal representative, well, they'll just have to wait 3 months and then your listing has expired because it's only valid for 90 days. All right, so selling the property. This is where it gets a bit confusing and you need to know whether your client has limited authority or full authority. Obviously, with full authority, it's a very simple process. You need to be familiar with the process, whether you're the listing agent or the buyer's agent, because if you're submitting an offer on behalf of your client and it's a probate sale, you want to make sure that you're not going to be stuck in escrow for 4 to 6 months because the personal representative has limited authority. So let's focus on this column on the left with full authority. Once the letters have been issued, you're going to list the property for sale and you're going to market it like you normally do any other property. You're going to receive offers and you're going to present those offers to the personal representative like you normally do. You're either going to counter or accept an offer. The reason I have in parentheses that the offer can be at any amount, the reason I don't say that to imply that you can undersell the property. No, obviously the personal representative has to sell it for the highest amount possible, but there's no restriction as to the house having to sell within 90% of the appraised value, which is required with limited authority. So you're either going to counter or accept an offer and you're not confined to any appraised value, nothing like that. You're going to open up escrow. The EMD is going to be what it normally is. The buyer conducts their inspections. Once the buyer has satisfied themselves and they, if they ask for a request for repairs or whatnot, once we have the final terms in place, then my office sends a notice of proposed action to all the beneficiaries entitled to notice. In the notice of proposed action, we tell the beneficiaries the personal representative has entered into contract to sell the property. If you object to it, you need to object within 15 days. So the person that receives the notice has 3 options. Either 1, they sign the consent form listed on the notice of proposed action. 2, they do nothing. So if they do nothing, it's treated as if they consented to the sale. Or lastly, they can object to the sale. If they object to the sale, then that takes us over here to this column. In my cases, when I've had a beneficiary object to the sale, I call them and ask them why. If they tell me, well, Georgina, I would be happier if the buyer offered $2,000 more. And then I have to knock some sense into them and tell them, well, if you think about it, if you're only objecting for those $2,000, it's going to cost the estate a lot more to proceed with court confirmation. And at the end of the day, you're going to get less money. Moreover, there's 5 of you, so those $2,000 divided by 5, it's not a lot of money. So most of the time they're willing to withdraw their objection. But just know it's not the end of the world if someone objects. We try to knock some sense into them, and if they're willing to sign the withdrawal of the objection, then you can proceed and close escrow. You cannot have an escrow under 15 days because the notice of proposed action gives the beneficiary 15 days to object. However, if the beneficiary sign a waiver to the notice of proposed action, then yeah, you can close in 5-7 days, however fast you can close. So as you can see, with full authority, it's like any normal transaction. So when you're representing a buyer and you're submitting an offer on a property that has full authority, don't be afraid, because it's like any normal transaction. The only difference is that at least 15 days prior to the close of escrow, we need to send a notice to all the heirs, and if someone objects, then that's where you're going to have a problem. However, if you're the buyer and someone objects to the sale, you can cancel and you're entitled to your EMD even though you have removed all your contingencies. The next and more complicated process is over here on the right, which is limited authority. The sale process takes about 4 months for limited authority. First and foremost, I have my office have the probate referee appraise the property. That takes anywhere from 4 to 6 weeks. Then we publish it in the newspaper that we're going to be selling the property. We list the property for sale and market it once we have received the value from the probate referee. You know, some attorneys do this backwards. I don't like doing that. Why? I want to know what the value is so that you, the realtor, know what is the lowest amount you can sell it for. Because if you undersell it and then you get the probate referee to appraise the property, you're not going to be able to sell it because the court will only approve a sales price within 90% of the appraised value. So then we open up escrow. The EMD has to match the amount listed on the publication. The buyer conducts their inspections. Once the buyer has satisfied themselves, then we file a petition with the court to approve the sale. Normally the hearing can be anywhere from 4 to 8 weeks out. We attend the hearing. Other people can show up to submit a higher bid. So it's likely that the buyer can walk away without empty-handed and someone else can buy the house at the hearing. The judge will sell it to the person that's willing to offer the highest amount possible. Then we obtain a certified copy of the order and we close escrow. So what is needed to close escrow? When you have full authority, the escrow company is going to require a certified copy of the letters. And then also they're going to need to have the attorney confirm with title that the notice of proposed action was mailed out to everyone and that no one objected. With limited authority, they're going to need the letters of administration and also the certified copy of the order authorizing the sale. So submitting an offer on a property that is in probate, you obviously have to use the probate purchase agreement, but I'm going to go over a new form. So this is to be used for residential sales. So the probate purchase agreement would be for residential properties. There's another addendum that you can use when it's a probate transaction, but it's a commercial, residential income, or vacant land. So on this form, let me see, where do I have it? Okay, so that's a probate purchase agreement. Obviously, this, what I highlighted, is what I was mentioning earlier, that if court confirmation is required because someone objected, the buyer has 3 days after being notified that someone objected to cancel the transaction, and they're entitled to their EMD. The other document that I was referring to, sorry, it kind of came out distorted. This is car form PAPA, purchase agreement probate addendum. You are going to incorporate this addendum when you're submitting an offer for vacant land, residential income, and commercial sale, or you're accepting it. So if you're the listing agent, make sure that if you're selling one of these 3 properties, that the offer is on the form specified for that specific property, but then the probate, the purchase agreement probate addendum is incorporated. And this one basically talks about what type of probate is it, is court confirmation required or not required. And then the second page, it actually deletes certain paragraphs from those agreements. I think I went over this before. Full authority, certified copy of the letters of administration, notice of proposed action, and any letters from the attorney. Limited authority would be the certified copy of the court order and the letters of administration. I think I covered everything. I know is a lot. I'm gonna open it up for questions, but lastly, here is my information. If any of your clients need to schedule consultation, they can book it on my website. These are the fees. The reason I have those consultations set up is that we need to run conflict checks before I give any legal advice to anyone. So I know a lot of times people will call me and say, well, Georgina, I just have a quick question regarding my client. I can't do that because I need to run conflict checks. So just make sure that your clients will schedule the appointment. That way I can run a conflict check, because it has happened where both sides of a dispute will contact my office, and obviously I can't be helping both sides. All right, so now I'm going to be taking questions. Let me see here. Hold on. If you think it's easier to speak your question, I can go ahead and unmute you, or you can unmute yourselves. But hold on, let me first answer some questions in the chat. Gail, hi, how are you doing?
Good to see you.
Nice. Well, I can't see you, but nice to hear your voice.
Oh, I'm gonna undo my video, so thank you. Good job.
Oh,
Always.
thank you. Thank you. So your question was, how does the court determine full limited authority? Most of the time they will give full authority, but if the decedent had a lot of creditors, they're going to give limited authority because they want to oversee the process a little bit more. Because remember, the courts have a duty to the creditors and to the children. Also, so that's, also if you have someone that's not directly related to the decedent. So let's say the decedent had children, but the children are not the personal representative, it's an uncle, then the courts kind of feel weird about that and want to protect the actual beneficiaries. As far as whether bond is required or not, also depends on the value of the estate and how many creditors the decedent had. San Bernardino, most of the time will require bond. Even if I have all the beneficiaries waive the requirement of bond, almost guaranteed in all my cases in San Bernardino County, the courts will require bond. In LA County, the courts are a little bit more lenient. And if all the beneficiaries agree to waive bond, then the courts will waive it. But if they get a list, because if we're asking to waive bond, we have to tell the court how many creditors exist. And so sometimes I have like a list of 30 creditors and over $100,000 are owed. The judge is going to say, no, you're going to get limited authority.
Oh, okay. So it depends on the number of creditors and the amount and all of.
And the value of the state.
And-
Also, if it's a very big estate, the court will require bond because it's a lot of money that if the personal representative does not act accordingly and they take off, then they're going to require bond.
Okay, and one last question. I don't want to take over because you may have other questions, but in limited authority, isn't it, it's still true, I think, that all contingencies have to be removed before it goes to court?
Yes.
Okay.
And
Great.
then you as the listing agent have to make sure that they remove them, because for one of the cases I had, I filed the petition and I told the realtor remove their contingencies. He never did. And so 3 weeks before the hearing, the buyer canceled. So luckily we got another buyer in and we amended the petition. So we were able to save that hearing date. But yes, make sure you remove the contingencies prior to the hearing.
Okay, and if they do that, they still get their deposit back if they get outbid in court, of course.
Yes,
Okay,
yes, they would.
Great, thank
Because
you.
that's not their fault.
Right, thank you.
You're welcome. So someone did raise their hand, but I guess, how am I able to see who raised their hand? Oh, I see here. Joy, okay, so can you unmute yourself, Joy?
Yes. And I also submitted my question, but
Oh, you did? I don't see it.
In the chat, I think her question is in the chat.
Joy?
Yes, do you
I
hear
don't
me?
see your question. Can you tell me what your question
Yeah,
was?
can I just ask it verbally?
Yes, of
You
course.
mentioned about the two kinds of probate that's in the beginning of the webinar. One is the full-blown probate, and what is the second one? What is the other one?
The other one would be the summary probate procedure. So all the other procedures that I mentioned, it would be the spousal property petition, or this one for property valued under 166,000.
Mhm.
Those are summary probate procedures. So those we don't have to worry about the statutory attorney's fees. We don't have to notify the creditors. We don't have to publish in a newspaper. It's a lot faster. We're in and out of probate court. Normally, the full-blown probate takes about 1.5 years to finalize. The summary probate ones, as soon as you have the hearing and you get the signed order, you're done.
Oh, and then that's the time we can get sign the listing contract, correct?
Yes, because if you have a summary probate procedure and the surviving spouse is now the owner, then they as the owner can now sign your listing agreement. You would sell it like a normal transaction. You wouldn't use the probate purchase agreement, none of that.
Oh, okay, yeah, because I have a listing coming up, but I can't list it because it needs to be probated because the wife passed away and she's the only owner of the property. So
Yeah, so there is that
it's a
spousal
very good,
property.
very good time for me to attend this webinar, and I thank you so much.
You're welcome.
I have another question though. Are you were we able to get a copy of the PowerPoint prints that you're showing us?
Yes, I'll go ahead and email it to the board and then they can send it out to everyone who attended, or just coordinate with them.
Okay, awesome. Thank you so much, Georgina. I really appreciate your
You're welcome.
webinar. Thank you.
You're welcome. So now I'm going to move on to Enriqueta. So we as agents still will need to coordinate the sale process with a probate attorney. Yes. When the clients don't have an attorney, can we refer them to your office? Yes. So for probates, some people decide to do them on their own. And I really don't recommend that because you're going to encounter so many issues. We as attorneys, we do this every single day. So we know the process. So if you're dealing with a client that doesn't have an attorney, you know, I don't know what to tell you, you know, hopefully everything is done properly. But yes, if there is an attorney on record, I coordinate with the listing agent because they'll need to send me the offer, the listing agreement, provide me an update on the sale, and then I'll send out the notice of proposed actions to everyone.
Yeah, because as an agent, I don't feel comfortable doing this all by myself. I mean, I don't know about the law, like,
Yeah, exactly. So how would you know, if they have limited authority, who's going to take care of publishing it, getting it appraised, filing the petition?
mhm.
The client's going to want you to do it.
Yeah, okay,
And
thank you.
yeah, so just have them speak with an attorney. Gail, if a sibling is the only heir and on title with the deceased sibling as tenants in common, did you say they can use a spousal petition process? No, the spousal property petition is only for the surviving spouse. But if the decedent's interest in the property is worth under 166,000, we can use a summary probate procedure. So you would have to kind of figure out, okay, at the time of this decedent's passing, was the decedent's interest in that property under 166,000? And if so, then you would use this procedure. Remember, the spousal property petition is only between spouses. You're welcome. Any other questions? That's it. No other questions before I end the meeting. I was left in charge, so I guess I can do as I please. But yeah, I don't see any other questions. No one else is going to unmute themselves to ask a question.
So we are gonna get a copy of the recording?
It's going to your board. So I don't know how they distribute it or make it available, but the recording is going to your board and I'll send them over the PowerPoint.
Okay, thank you.
I have
Thank you,
another
Gail.
one,
Have a nice
Gabrielle.
day.
I'm sorry. I have another one. This is Joy again.
Okay, what's your question, Joy?
You mentioned something about the schedule of assets. Where do we get the schedule of assets for? I think this is part of
The
the
EGGSTAD petition.
Yes.
So if you go on a listing appointment and you realize that the title is not in the name of the trust, it's very likely that we're going to have to do the EGGSTAD petition. So the schedule of assets is normally found at the end of the trust agreement. So if you flip to the very end of the trust and it says schedule of assets and the house you're trying to sell is listed there, then it's very likely that the judge will approve the EGGSTAD petition. I've had cases where the EGGSTAD petitions are denied. Obviously, I tell my clients up front and tell them, this one, I don't think it's going to be a go, but if you want to give it a shot, let's do it. But yes, not all EGGSTAD petitions are approved, but if you have the property listed on the schedule of assets, it's very likely that it will get approved.
Okay, so it's in the trust itself at the end of the
Yes.
Okay.
Melanie is asking if I do quiet title action. Yes, I do a lot of civil litigation. With my civil litigation practice, I handle quiet title cases. All right, so Karen raised her hand. Karen, can you unmute yourself?
Yeah, thank you.
Okay, there you go.
Quick question. So when you're taking a probate or when you're taking a listing, is it advisable to take a POA and a transfer upon death deed just in case something happens to the spouse or either spouses when it comes to yeah, go ahead.
No, well, if the spouses are on title as husband and wife or as joint tenants, if either of them were to pass away during the transaction, everything would go to the surviving spouse. So you would just have to confirm that that vesting is either as husband and wife as community property or as joint tenants.
Okay. All right, thank you. Just
You're
wanted to
welcome.
clear that up. So
Yes.
I've been dealing with a spouse that's in the hospital right now. So
Oh, I see. So yeah, check how title is taken, but then it wouldn't be a bad idea to have the power of attorney in case she loses capacity during the transaction.
okay.
But if she passes away or he passes away, investing is as joint tenants or husband and wife, then it would automatically go to the surviving spouse.
And that's if they have a trust or a living will, right? But
No,
without-
so
okay.
if title, so you look at the last recorded deed. If the
Uh-huh.
last recorded deed says husband and wife as joint tenants, either of them passes away, it automatically goes to the surviving spouse.
Okay.
If they have a trust, the trust itself would provide what would happen upon the passing of one of them, but you would have to make sure that title is actually in the name of the trust.
Okay. Sounds good. Thank you.
You're welcome. Any other questions?
Very good. That's it. Thank you.
All right, well, good luck everyone and have a nice day. We'll be in touch.
Thank you so much. Thank you.
Bye.
Appreciate it.
You're welcome.